Welcome back, everyone. It is a pleasure to welcome you back here to our conference on digital governance in the times of COVID-19. And thank you all for joining us on our third panel of the conference, which is dedicating to discussing the incorporation of technology in court proceedings during the time of the COVID-19 pandemic, but also beyond that and the times before the pandemic started. My name is Ayelet Sela. I'm a researcher in this field here at the Bar-Ilan University Faculty of Law. And we are happy to hold this event in collaboration with the Jean Monnet Center of Excellence on Digital Governance, which is a collaboration of our faculty with the Erasmus University School of Law and the University of Leeds School of Law. And I am extremely delighted to host here today with us three wonderful speakers whom I will soon present in greater detail. And in broad terms, our panelists will help us explore the potential of online courts to improve access to justice. And they will also help us touch on some of the concerns that the transition to online court processes raises. And our panelists today are Professor Amy Schmitz from the University of Missouri School of Law, Dr. Erlis Themeli from Erasmus University in Rotterdam, and Ms. Qudsiya Naqui, who's an advocate with the Pew Charitable Trust. Now, I think it's interesting to point out before I introduce our speakers that before the COVID-19 crisis, a panel like this one would likely begin by noting that commonly expressed, I think, resistance, even fear that courts and judges have in the face of even the mere proposition of conducting court proceedings online, especially if we're talking about trials. But now, a year into the social distancing restrictions that the pandemic imposed, I think both the institutions as a whole and different actors, including judges, are much more receptive to this idea. And at the same time, and I hope that our panel discussion will help shed light on this, these notions, online courts still present many, many unresolved challenges. They include at this point in time evaluating what the actual impact of transitioning courts online has on access to justice, on procedural justice, on distributive justice, and generally on the rule of law as a whole. I'm sure we'll hear more about that from our speakers. But, and I hope that we keep that in mind as we progress in our discussion, at the same time, I think we have to make sure that we don't limit our conceptualization of online courts to e-filing and online hearings. And I do hope that courts will take this opportunity that now we have necessity presented with us to embark on a much deeper and broader exploration of the potential that advanced technologies and user interfaces present in transforming access to justice and the way justice is delivered altogether. And on this final point, I'll just note that you're all invited to stick around after our panel to the keynote talk by Professor Richard Susskind, who will shortly shed more light and present more ideas on this matter. And finally, before we start, I want to invite our very diverse audience to present questions to our speakers. You can use the Q&A function of Zoom, and you're also welcome to engage in a discussion or just offer some comments using the chat. And now, without further ado, I want to present our first panelist, Professor Amy Schmitz, who is the Elwood L. Thomas Missouri Endowed Professor of Law at the University of Missouri School of Law and the Center of Dispute Resolution at the university. And Amy is a leading researcher in the area of online dispute resolution now for many years. And she's also a very active member of many organizations and associations in this field. I won't list them all, but they include her being a fellow at the National Center of Technology and Dispute Resolution, the co-chair of the ABA Technology Committee and the Dispute Resolution Section, and the ODR Task Force. And she's also a researcher with the Autonomy Through Cyber Justice Technology project in the Cyber Justice Lab at the University of Montreal, where she's exploring the cutting-edge intersections of AI and ODR. So Professor Schmitz, thank you very much for joining us here today, and the floor is yours.
So first of all, thank you above all, and it's so good to see you all. Wish we were all in person. And I definitely, just a huge thanks to Bar-Ilan and to Professor Sela. Thank you so much, I really appreciate it. I'm gonna go ahead and share screen so we can get the slides underway. Okay, so I'm hoping everything, we are good to go and everyone's able to see okay.
We can see it, thank you.
Great, okay. So as I begin, I wanted to first of all note something Dr. Sela had also mentioned, and I really want to emphasize, is a lot of this research was underway before COVID-19. Many of us in the field have been studying online dispute resolution for 20 years. And now COVID-19 has really sort of pushed us right to the fore in terms of bringing the idea of digital justice to light. But in fact, for example, this paper I'm presenting today, I had researched and written before COVID-19, but I think it becomes all the more relevant. And if I would like to kind of start with a theme, building on what Dr. Sela said, I feel strongly we need to think about, at this moment, the 4 R's. And the 4 R's are going to remain a constant through my presentation as a theme. In the sense, number 1, research. We absolutely need to engage in deep empirical research as we look at these court ODR programs and we assess what works, what doesn't work. Then,
sorry, just stop you quickly because you're sharing your split screen as a presentation mode rather than the presentation, if you'd like to.
Oh, absolutely, sorry. It just shows the...
It's fine, we just see this slightly smaller than the full screen.
Isn't that perfect? The person who's supposed to be the ODR expert in my, it's not. Oh my goodness gracious. Can you see the full screen now?
It's better this way. We see it larger. We see your slides on the side, but it's fine.
Okay.
Yeah, that's great.
If I may, probably Amy is using 2 screens. And then she's sharing the screen with the 2 slides.
I am, yes. So, well, let's go with, as long as you can see okay, right? As we are now?
Yeah.
And you don't see my other screen, correct?
Yes, it's perfect.
Okay. All right, I will fix this later. That's perfect. Well, it just shows, actually, I'm going to use it as part of my presentation, that technology doesn't even work sometimes even as much as we believe it will. So again, I begin with a research, looking into these different programs, doing deep, serious research, and then revising the programs and to address the problems that we discover, repeating that process in order to better create programs that are user-centric and user-friendly, and really a way to kind of reimagine access to justice and not simply repeat what we currently do in a traditional face-to-face world. I think there's a lot of movement for that. So as we begin and you think about online dispute resolution through the lens of access to justice, I believe it is an exercise in functional analysis, because at the end of the day, many of us go back and we think, why did we ever become interested in online dispute resolution? And I tell you, I, for one, and many others, only became interested in ODR because we saw it as a way to expand access to justice. So it brings us back to thinking, okay, number 1, what does it even include, right? So even if you want to sort of go back in time, and I know my fellow panelists will be talking more about court programs in particular. So I think it is important to sort of set the stage. What are we talking about? So it can include many different things when it comes to this world of ODR. It is growing, it is expanding, it is maturing. It can include problem diagnosis, wizards, AI being assisted, Also, negotiation portals being aided by e-nudging, as Dr. Sela talks about in her work, as well as online platforms, of course, for mediation, for evaluation, and essentially online arbitration. So there's a broad sort of tools for problem solving that are in our toolbox. And we have to think, when you do a deep functional analysis, what are the reasons that we even thought about these different processes and how technology might actually help us expand access to justice? We had to think about the reasons why over the last 20 years, ODR has grown from just simply being something eBay used to something we're seeing in the courts of law for many different areas, right? Because litigation face-to-face, we know it's costly. Consumers, my own work, I've done empirical research on consumers' access to remedies, and consumers want mobile access to remedies these days. And consumers are not willing to go to court and pay the money or deal with the hassles. Also, data analytics and online neutrals can assist with resolutions, and we're all seeing how face-to-face involves hassle, travel, time off of work, and now, of course, health risks in the age of COVID-19. Again, it also can adapt to language, education, physical, and time differences, especially if it's properly created. It can also cut costs. I know with Her Majesty's online courts in the UK, one of the main reasons was austerity. It was an austerity measure to try to save money, and that is absolutely true in the US as well. Also, again, these online wizards and chatbots to empower self-represented litigants. In fact, again, my own journey in ODR began with thinking about self-represented litigants and how do we help them get remedies in systems where they can't afford lawyers, right? And I can't afford a lawyer. I mean, it's very difficult. The face-to-face process has become very prohibitive. Also, the space that is created by computer-mediated communication. It can ease stress. It can, for many of us, we think about how we will be treated in a court that can seem rather stressful. And so providing these alternative ways to access remedies and to have a voice is very, very vital. When we think about the evolution, again, this is going to be a quick journey through the evolution that started with companies like eBay. eBay is a perfect example. It's been around, that was in the late 1990s when they started using online dispute resolution for these business to consumer transactions, right? We saw it as just simply something that companies do for goodwill. But no, now the leap has been made, and we see companies like Matterhorn. Matterhorn is a company that is operating many ODR systems for the courts throughout the world. Again, we saw, going from e-commerce to these different court ODR processes. In fact, Modria was bought out by Tyler Technologies in the United States, and they are operating many, many ODR programs throughout the world. Of course, Matterhorn. There's also TurboCourt and others that are in and moving quickly. If you go to odr.info, you can see a provider list, and that provider list is growing every day with different ODR providers that are partnering with courts, right? And we see different types of court processes. You see Utah, for example, where it's homegrown. They're using their own system. But in contrast, you see in Ohio, in Michigan, in Nevada, in Texas, in New York, where they are partnering with private organizations. We can say, again, just thinking it through, good, right? We want to promote innovation. We want to promote access to justice. But what does that mean for transparency when you have private-public partnerships of this type? Just to give you sort of a snapshot, and this is, again, pre-pandemic, okay? Pre-pandemic, and this is in the United States only. But look at the growth. This was provided by the American Bar Association and their Center for Innovation. But I think this shows us from 2014 to 2019, these are just ODR, court ODR sites added per year. And you can bet that that number is now doubled for 2020 and 2021. Again, you see this expansion. Interestingly, and again, going back to the public-private partnership and why this is important, Michigan has grown by leaps and bounds. And partly because Matterhorn is based in Michigan and they are operating many systems in Michigan. Outside of the US, Indeed, I would argue Canada is a world leader in online dispute resolution. The CRT has grown and they have revised their plans each year. They are now even handling personal injury for online dispute resolution. Parlay has also grown out of Cyber Justice Laboratory, and Cyber Justice Laboratory has got new projects underway every day and incorporating AI as well. China has a Hangzhou Internet Court. There's been some concerns about bias, but nonetheless, it is there and it is robust. We have Her Majesty's Online Court, as mentioned earlier. And then, of course, in the EU, you have the platform via the ODR regulation. There's some question when you look at the data as to whether or not it's gained enough traction, but it is growing. And if you look at the numbers, Germany in particular has been robust in using it. And we're going to hear from other speakers on the European front, which is definitely growing as well. Now the CRT, just to give you, again, just a whirlwind sort of background here, they've really done the kind of 4 hours in the sense that they have continually been researching to discover what needs to be addressed and problems in their processes. Then they go ahead and revise the process and repeat that cycle in order to really kind of think about how they can reimagine access to justice and seek different ways to be user-centric and user-friendly. So the CRT, the Civil Resolution Tribunal, I invite you to check out their website at civilresolutionbc.ca. They also publish a lot of their survey results, which is helpful. And I would, if you want to take I'm giving you the big picture, right, before you kind of drill down into the different pieces to this puzzle. And it really becomes kind of a contextual dispute resolution puzzle in the sense of fitting not only the forum to the fuss, as we talk about in dispute resolution, but fitting the tech to the fuss, meaning the type of dispute at hand. And some of the areas, the biggest growth areas for court ODR include small claims, and in some cases, they're moving in the direction of making it mandatory. Tax appeals has been quite popular. Ohio is a very good example of that. Traffic tickets. Now we can argue whether it looks more like click and settle, but we do see a lot of traffic ticket programs. And family context for both pre and post decree, and then condo and landlord tenant. I will tell you, landlord tenant is growing by leaps and bounds in the wake of COVID-19, because how do we deal with the flood of eviction cases? And you see groups like Legal Aid. In fact, in my class this afternoon, I teach a class in ODR. We're going to have the leader of Legal and Legal Aid to discuss the different programs underway for online dispute resolution in eviction cases to deal with essentially what could be a crisis with the backlog that now exists on these eviction cases. Again, this is just per a 2020 ABA report, but you do see traffic as the largest area, warrant cases. But again, I would argue that landlord tenant, it's now much, much larger. Small claims is now much, much larger in the wake of COVID-19. Also, again, just seeing this expansion into landlord tenant and debt. Another area, civil debt, is growing by leaps and bounds. I will tell you, New York has now opened the Manhattan Civil Court for small claims as well. Now, we see this frenzy. It's sort of this rush to digitize that has been happening. But I really argue it's time to just take a pause and ask, but is it fair and why do we care? And I would argue that it is absolutely essential. Again, going back to the functional analysis, going back to the reason why ODR even became a thing, was a way to expand access to justice. So we do have to stop and ask ourselves. And Fordham has worked on this Access to Justice Index. I also welcome you to read the work of Rebecca Sandifer, a lot of work about what is access to justice, right? So what are the components we need to think about as researchers when we're looking at these different processes? Number one, a fair chance to be heard, regardless of who you are, where you live, how much money you have. And also, at a minimum, to learn about her rights. This is important. This is where AI can be very helpful, and these wizards and problem diagnosis software, okay? Also, giving voice and having a neutral and non-discriminatory formal or informal process that helps determine the facts, applies the rule of law, and enforces the result. So it's a lot to ask for, but we have to strive for these pieces. And again, going back to some of the research from the ABA Center for Innovation, Look at this slide, right? This was a survey, again, this is prior to the pandemic, but it was asking about features of the current ODR systems in place. I find this worrisome. Just take a look. I hope you see some of this as worrisome as well. Accessible for people with disabilities. 71% say unknown, only 24% say yes. Non-English language in the US, 71% unknown, only 21% say yes. Provides legal information, only 32% says yes. Now, electronic document management, sure, we have 79% that say yes. So it goes back to what Dr. Sela said. We need to think about more than e-filing. It's not just about being able to upload your documents. If we go back and we think about, wait, what is access to justice? It is not simply uploading documents. There's so much more we can do to reimagine access to justice. So how should we approach access to justice research? And again, just a few things to think about. We do have a speaker here. I'm very excited to hear from her. The Pew Charitable Trust is engaging in some very important work. I had the pleasure to recently read the report that has already come out of the project that Arizona State is commandeering. Some really important pieces that are happening. Pilot court sites where they are conducting research. Also, the National Center for State Courts is conducting process evaluations on a sample of pilot courts and assisting with stakeholder engagement. And so we're going to see a lot of research coming out of these different programs. And overall, if we want to take a big picture, I always like to keep it simple in my feeble brain. And when I think about framing, I think it's really important, just very simple, who, how, and what. Who, how, and what. I think it's vital to look at, number one, who. Do these programs actually open up access to justice for those without representation? Are we simply letting the haves have more, or are we letting the have-nots have something? That's important. So we have to look at who. Who are the individuals using these new processes that are being built throughout the world? The US is not alone. Again, this is throughout the world, these ODR projects happening in the courts. And what about those who face other resource barriers, language, ability, education, physical barriers? Are they able to use the process? How? This is really important. This is user perceive the process as fair, and does it work well? Is it user-centric? We can actually gauge on the back end whether or not individuals are dropping out of the process out of frustration. What about real-time user experience testing? Not simply post hoc surveys, but real-time user testing. This is absolutely essential, and we have a lot of nice means for doing that today. In fact, Arizona used some of these means, and I know here at Mizzou, at my university, we also have developed different ways for real-time user experience testing. Really essential. And what? Do the ODR users get a fair or different remedy than they would obtain through court or other face-to-face processes? And this is where I argue we have to think broadly, because whenever you look at dispute system design, it's important to ask, compared to what? And when it comes to, for example, consumers' access to remedies, compared to what is more complicated? It's more complicated because my own empirical research and others have found that many consumers never go to any kind of a court with a consumer problem. So you have to look at these alternative access points that consumers are using. Here in the US, for example, consumers file claims with the Better Business Bureau, with the FTC, and with the Consumer Financial Protection Bureau. So you need to look at these alternative means that consumers are using for access to remedies. So when you do that comparison, it has to be deeper and more nuanced than simply looking at court processes. Also, absolutely essential, ethics, transparency, and best practices. I am passionate about these issues. In fact, the ODR task force in the US, that also includes international actors, and we have the International Council on ODR involved so we can get collaborative buy-in, but we are looking at best practices and ethics at a very deep level. And it's important to craft user testing to uncover what works and doesn't work. Even sort of a non-scientific research that I had done with another person in the world of ODR. And you know, one thing we've learned already is that people at this stage in the process really need to have helpers, live helpers available for these court ODR programs. You can't just unleash it and leave consumers at their peril. You need to have live, and that happened because of user testing. Also, looking at quality and privacy protocols could not be more important in this age of cybersecurity. Also, again, transparency and publication of results to the greatest extent possible. This is a huge issue, especially with the public-private partnerships. What happens to that data? Is that merely going to be used for lead generation by these private companies? Or are we going to use this data in order to reimagine and revise these processes to make them better? Also, having qualitative and quantitative studies. And again, crafting technologies to enhance access to justice for everyone. And just to go through quickly, I welcome you to check out icoder.org, because they do have ethical standards that have been put forth by iCoder, and it is the backbone for the task force, in fact, that I'm working on. And a lot of these are pretty self-explanatory, so I won't linger long, but I think it's important that we constantly, as we're doing this research, as we're thinking about court ODR processes, I think it's absolutely essential that in the back of our minds, we're in the forefront of our minds, we're thinking about, is this accessible? Is it easy for people to find and to participate in these processes? In fact, one of the findings out of the Arizona State study was people weren't sure if the website was legitimate because it didn't have the state logo, it wasn't easy to find, it seemed as though it was an illegitimate website. That right there just shows it was not sufficiently accessible for the average individual. That's a problem. That's something we can work on, though. It's something we can address and fix. Accountable, continuously accountable to institutions, legal frameworks, and the communities they serve. You know, competent becomes really important. Is it run by the people with the relative expertise in dispute resolution? Another question, in a lot of these situations, you have designers that are maybe technologists, which is great, but they might be purely technologists that weren't sitting at the table with the people who are worried about due process or the individuals who are dispute resolution specialists. You need everyone at the table working collaboratively, having individuals that you're not competent if you don't have the proper expertise all sitting at the same table when you think about proper dispute system design. Also, of course, confidentiality and being respectful to the parties in knowing how much and making sure that they know what kind of information is being shared. And then also, of course, equal in making sure repeat player advantages are kept in check, quickly, fair, impartial, neutral, legal, secure, going back to cybersecurity, and transparency. Transparency, there's a tension with confidentiality, but it's something to think about, and making full disclosures and knowing precisely the risks and benefits of participation to individuals involved. So finally, again, research, revise, repeat, so we can reimagine access to justice. I think it's not simple, but we're up to the challenge. I think we can reimagine and think creatively about how to use technology, and be aware that there are dangers to digitizing due process, but user-centric design is going to continually evolve based on solid research. Again, thank you so much. Those who are interested, there's the paper in the Fordham Law Review. And I thank you immensely for taking your time. And sorry about my slides not working in the beginning. Hopefully we're all good now, though.
So thank you very much, Professor Schmitz. This was really interesting, and we have a lot of information there to tackle. So I see that there are already some questions being accumulated. So I invite the audience to add more questions in the Q&A. I do want to start us off with a couple of questions, one to which you referred, and I want to poke you a little more on it, which is, how do we incorporate user testing in court processes as we go along? And what are your thoughts about how this could be done, especially given the difficulty that courts face in ensuring, equal treatment and procedural justice. And we do know the research about how this ongoing user testing, which involves perhaps changing some elements in the platform, could impact the outcomes, the behavior of the parties, potentially the decision of the judicial officer or judge that is presiding on the case. So that's a first question. And then the second question is more forward-looking, given your work, which you have not discussed today, on the intersection of AI and ODR, and particularly of interest to our audience today, the potential of AI in courts. What do you see in the future with respect to that, and how should courts approach that and tackle the difficulties of algorithmic decision-making, or even just assisted algorithmic decisions? Just a couple of questions to start us off. And again, the audience is invited to present more questions in the Q&A.
Yeah, no, thank you. And to be quite honest, I could spend an hour on each of those questions. So I'll do my best to sort of give a quick answer to each of them, because those are very rich and amazing, really great questions that are so important, and could be an hour-long discussion on each. So first of all, as far as user testing, I think there's a lot of different ways. Of course, there are discussions, and many have talked about randomized control trials in this area, Rebecca Sandifer for one, and others. I'm not sure that I have trouble. How do you deal with kind of who gets the placebo question, right? In terms of giving different individuals different processes, and then how does that impact the outcomes, right? And so I do have trouble with that. I'm not, I don't think we should sort of fool with people's access to justice, especially when we're talking about their lives and real claims, right? And so I do think there's some concerns about that, sort of using real cases. But I do think you could do a randomized control trial using, for example, students. To be honest, I mean, my students try out different technologies in class and do exercises using different technologies. So in some ways, user testing is happening in universities all over in simulations, right? And I know it's a simulation, it's not a real case, but you would not believe, I mean, I'm sure you see this in your own work, Dr. Sela, with students. I mean, it's really quite amazing how you notice and how students can uncover really important points in using different processes. So I do think there is definitely a lot there and room for that kind of research. I also think using, for example, one thing we had looked at the University of Missouri is some of my technologist friends in creating an app where you can use this alongside while you're going with the process and recording how you're feeling about the process as you go through and catching each piece in real time. So you're finding out from the user how they feel about the process, and also gathering points of reference and ideas throughout from step to step to step. You know, I think that is incredibly robust, and it's better, you know, having done my own empirical research years and years ago, that really was kind of this post hoc, you know, surveying and focus groups. You know, people revise how they feel about a process. You know, they revise it based on, did they win, did they lose? I mean, there's a lot to unpack there. So getting that sort of real time in the moment is really amazing. Getting that kind of feedback, I think, is really helpful. So I would say those are two things that are untapped to some extent, and there's a lot more that can be done. But there's absolutely, and some of these apps that they've developed just simply for gathering research are really very robust, and you can even use voice activated, of course, and make it easy for the participants so they're not, you know, typing anything in. And so it makes it easy on the user as well. And so that is another kind of new frontier, I would argue, with respect to user testing and really thinking deeply. Also, another important point, though, is to make sure who's involved, right? Not just simply the person who volunteered because they took your class in ODR. No, we're talking about getting real people and, I mean, offering. So even when I did focus groups on consumers' access to justice years ago, I went to downtown Denver, Colorado, and I did offer free lunch. It is true. And often that is, you know, part of what happens. And I recruited people, and it was regular people, getting people from all walks of life and making sure that it wasn't just self-selected individuals who maybe took a class and are interested in the process, right? Or already are tech savvy. So you want the people, laughingly at the ODR forum, maybe you remember somebody asked me, well, what should we think about when we're crafting these ODR designs? And I said, well, I would ask my mom. And I still mean that, you know, making sure people of a certain age are also involved in the user testing and feel comfortable with these processes. My parents,
Maybe I want to make time that I want to make sure we have time also for
audience
absolutely.
questions. So
again, a brief response quickly, to the AI in courts question, and then we have another one from the audience.
100% AI. We need to look under the hood. You need to look at what's the data you're using. If you're building it based on bad data, you know, bad data in, bad data out. So I think absolutely looking under the hood, knowing what you're using as your data points, and that is going to be very vital as we look to using data and building on it for any kind of a chatbot or AI to help self-represent litigants.
Thank you. So we have a question from Shmuel Yerushalmi. It's in relation to the use of online courts in criminal proceedings, and particularly whether when courts require prisoners or detainees to use online proceedings, that is a violation of their elementary rights in the process. And particularly referring also to the question of an open court and the public element of legal proceedings. So I think that's in place, and we are talking predominantly in ODR about civil proceedings, but I think it's important to also note what's happening in the criminal field.
Yeah, I mean, I have some concerns about that. There's some early research coming out of the UK that detainees are getting different deals based on whether it was face-to-face or online or a virtual hearing. So I do think there's a certain amount of concern and caution. Absolutely, I think we have to think creatively. I know there are some courts using YouTube or other means in order to make it public. And that certainly is important for digital governance. But again, that would be a whole another hour. So I don't want to take up all the time, but I do think there's a lot of nuanced considerations about how detainees especially are impacted by virtual hearings.
Thank you. And I would add to Amy's response that we actually have now several empirical studies. I myself am conducting one with a collaborator, Hadar Danzig-Rosenberg, where we're trying to track using the kind of questions that Professor Schmitz presented earlier. What is the impact of transitioning these hearings online, especially in the criminal context? So I think that we now have an opportunity following the circumstances imposed by COVID-19 to actually offer some empirical evidence and provide some answers to these questions. But importantly, this also requires research with the prisoners and detainees themselves, which is much more complicated and sensitive to conduct. And so I do hope that there will be response also from prison authorities and from other involved public agencies so that we can get the full and well-rounded picture on this. So yeah, I agree, it's a very important question. So thank you to Amy Schmitz again, and I'm happy to invite now our second speaker in the panel, Dr. Erlis Themeli from Erasmus School of Law, where he's a postdoctoral researcher in a project on the digitization of civil procedure, which is part of an ERC-supported project on building EU civil justice. And in this context, Dr. Themeli is looking at digital access to justice in court proceedings and the use of artificial intelligence in decision-making. And through his work, I believe he aims to develop a broader normative framework for accessible civil procedures, ones that meet the demands of procedural justice in particular. And luckily, unlike other panelists on our panel, Dr. Themeli actually had a chance to visit us in person at Bar-Ilan last year as part of our academic collaboration with the Erasmus Law School in Rotterdam. So it is a great pleasure to welcome you here again virtually for our conference. And the floor is yours. Thank you.
Thank you for having me. And
and I'll just remind our audience again that they are free to add questions in the Q&A function during your talk so that we can use them in the discussion later. So thank you.
I hope I'm sharing the right screen.
We can see your presentation, yeah. If you would like to put it in presentation mode, yeah, that's perfect.
Perfect, yes, okay, thank you. So yeah, it is indeed, I'm both happy, but also unhappy for not being there. I'm happy for not being there just to show that technology and remote technology can connect people and can be used in court as well. And it goes without saying, actually, that COVID-19 affected courts in the Netherlands, although at the beginning, courts were not considered as essential institutions. And what do I mean by that is that in the Netherlands, when everything started and all the restrictions started, certain institutions like supermarkets were considered essential, so they were allowed to stay open, but courts closed down. Well, but courts certainly are essential institution, and it shows by the care that the Dutch government, that the Dutch society has about them. And in fact, Dutch courts before COVID-19 scored quite high in international rankings. This is, for example, the Rule of Law Index from the World Justice Project. And in this ranking, the Dutch courts are third in the world after Denmark and Norway. It is quite interesting actually to show at the details where do Dutch courts perform better, but for us it's more interesting to look at where don't they score better in this particular index. And according to it, the Dutch courts are not performing so well as regards delay. In fact, they are quite behind other courts, and it shows that despite being quite high in the ranking, problems exist. Problems of delay, problems with sometimes affordable civil justice, even though they score second, still persist in the Netherlands. And while rankings can be helpful to understand, or can be helpful to show pride, they should also be taken more seriously as regards the problems that they show. And here is, for example, the ranking that the EU Civil Justice Scoreboards had in 2018. This is actually a calculation that I have done, and it is more related to commercial litigation. However, it still indicates that Dutch courts perform well. But if we go and look at the details of the problems that have been highlighted by researchers and by practice, it shows that law procedures and legal language in the Netherlands is quite complex. Speed, therefore, cost are sometimes to worry about, in particular the unpredictability and the duration of the proceeding, which means that for low value claims, courts are too expensive and time consuming. And also Professor Schmitz highlighted that for consumers, it is becoming prohibitive to go actually to court. And according to some calculation, all civil law problems, of all the civil law problems that exist in the Netherlands, only 35% go to court. The other try to find some solution out of the court. So this creates the perception that courts are for the fewer and fewer people, perhaps even elite institutions. To make matters worse, courts' budget is shrinking while cases become more and more complex. In reality, it may be a solution to create specialized courts. The Netherlands created the Netherlands commercial courts partially in response to this need for specialized institutions. Another problem that we see is that litigants with low education and low income find it difficult to start a court case, especially when considering that the number of self-represented litigants has increased in the Netherlands in view of recent reforms. So the judiciary should be better at providing information for these people. So for self-represented, yes, but also for others even more. And the failure to introduce information technology in courts perhaps exacerbated this situation. So let's take a look at what is happening with ICT in Dutch courts. This is again the ranking of all EU member states according to the EU Civil Justice Scoreboard for 2020. The data are a bit obsolete, well, maybe old from 2018. Things may have changed so far, but still, and of course, there may be some objections about the methodology, but still we can see here that the Netherlands scores quite low. And if we think that the Netherlands and its judiciary is one of the best in the world, we see that for ICT, the availability of means is quite scarce. If we look in details at what this score comes from, we can see that while indeed the tools available to judges and to court clerks score quite high. The same is true also for the administration and the management, but where it's lacking, it's perhaps the communication between court users and the court, which is the green bars in the charts. Now, another interesting detail is also the score that the Dutch courts get from the for the training of the judges. If you see, quite some countries provide a lot of training in IT skills. For example, Denmark, which ranks better than the Netherlands, provide a lot of IT skills for judges. Meanwhile, the Netherlands provide quite a tiny percentage compared to the Netherlands. Of course, there might be, again, questions about the methodology, the way this training is provided and how it is reported for this. But what is important here is the Netherlands perhaps needs to do more about or needed to do more about digitization and IT services in courts. And of course, a part of this is because court budgets have been shrinking, as I mentioned. If we look at the numbers, we may see that while figures show an increase in the budget, but taking into account also the inflation, most probably the budget, the court budget for 2018 is much lower than the court budget in 2010. And again, if we look at computerization, which is a term used by the CEPEJ, which is the European Commission for the Efficiency of Justice, computerization means all the investment that is doing, all the investment in ICT infrastructure. We can see that again, the numbers remain quite the same, although there is a spike in 2017. I'll explain that later. But again, the numbers are quite constant. And if we take into account, again, inflation, we may say that maybe in 2018, the budget has decreased compared to 2010. Then, okay, the Netherlands needs to do more on ICT, but actually what did it do? The fact is that in 2012, the Netherlands started a big project called Quality and Innovation. The aim of the project was to maintain the reputation and the quality of the Dutch judiciary, and to strengthen some of its aspects. And the way to do it was to improve and to innovate justice by including electronic means and tools, and by improving the legislation in order to help the use of these tools. And again, it rightly identified the problems that the judiciary was facing, which was communication with between courts, communication between courts and court users, the need for shortening and improving proceedings, and the need to reduce complexity. Therefore, the reforms aid to limit somehow the submission rounds for the court, to increase the management powers of the court, to create custom proceedings in order to tackle the underlying dispute, rather than to have proceedings for the sake of having proceedings, and then emphasis on settlement. The idea was to give parties the chance to resolve rather than to be in court to quarrel. And of course, the idea was to create an environment, an online environment, where lawyers would have this My Case interface, where they can they could drop documents, they can see and receive documents for their cases. There would be a calendar there, which the parties can see and agree on how a certain case would be handled. It was agreed that, well, it was considered that the hearings would be oral, in person, or video conferencing. But again, what was more important was that the video conference and the digital means were being put in place. On the other hand, judges were having this My Work space, which would allow them to exchange documents between each other and between the court. However, what happened is that in 2018, and that is after 2017, which probably which a lot of many of these investments were performed, the Dutch Council for the Judiciary and the Dutch Minister of Justice decided to freeze the project. And actually, since then, nothing happened. One positive aspect of this project, however, was that the Supreme Court actually has been quite digitized, and it can allow, or it used to allow, and it still does, its constituents to use the digital means. But actually, what were the problems of this project are quite interesting, because it allows for improvement in the future. Well, for one, it was mentioned that it was it would be problematic if this digitization would be so sudden, because it would create or increase barriers for older citizens, for low-income groups, for those that are not so tech savvy, and would create more limitation to people that that are already facing difficulties. This is something also that Professor Schmitz mentioned. In details, the problems that Quality and Innovation Project faced were that it was perhaps too ambitious. It was quite complex, also because it was the duties of several institutions were vaguely defined, and there was an ambiguity in between dividing tasks. So you can understand that it was quite a mess in that regard. However, soon enough, a new mess came, which was COVID-19. And once COVID-19, well, how do I say, started or happened, the Dutch courts, the Dutch government, the Dutch society, and everyone else in the world actually were quite puzzled. What do we do? So the reaction to the pandemic was kind of divided into three phases. Phase one happened in between 17 March and 6 April 2020. And in that phase, only very urgent cases were dealt, and not in persons, but online or via telephone. So sometimes the courts were using Skype for business, and other times when it was not possible, even telephone was used. On phase two, which was, and this phase actually coincide also with, let's say, the kind of panic reaction of the government to the pandemic. So first, everything was shut down in the Netherlands, as I said, only supermarkets, and I think only supermarkets were open so that people would buy food. And phase two, which was in between 7 April and 10 May, things started to get relaxed, also because I'm not sure about numbers, but probably the governments were was feeling more comfortable with the situation, but also because the courts themselves started to prepare about that situation. So it allowed also urgent cases to be handled via online or telephone. Meanwhile, all the judges were sitting home, and they were on the positive side, they were working on the backlog that they had, and on the negative side, they were stressing out because of the situation. Phase three happened, or is the current one, and it started on May 11, 2020, and is predicted to last until the 1st of April of this year, but it will be decided by the governments how things will proceed. And during this third phase, hearings again started, courts open, and there it is possible to go to court as well. Again, to be physically present there. Of course, masks are obligatory, and COVID-19 rules should be followed. It is possible to attend decisions, but then hearings, but then you need to take to ask permission. And what happens also during this phase was that the court provided for a system that would allow parties to exchange documents via safe mail, and provided for also the possibility to have all the hearings. Despite the possibility to be physically there, the parties could choose also to have everything online, and to use these systems. I must say that actually things looked a bit spontaneous rather than very well programmed. And of course, no one could imagine the pandemic. So out of this spontaneity, some tools were created. However, problems also were created. Some procedures so I should clarify this because of these phases and because of the new way to proceed. So and because of the use of the electronic means. the judiciary created special procedures in order to handle cases faster without public and by using electronic means. However, this slimmed down procedure may have created or may have be in violation of Article 6 of the Convention on Human Rights. There has been cases judged by the Supreme Court of the Netherlands, in which prisoners have complained about contacting the judge via phone. They were complaining that this was a violation to their fair trial rights, because they were claiming that they needed to be in front of the judge with their lawyer by their side, and so on and so forth. However, the court said because of the special situation and because of the pandemic, it was fine for you to meet the judge via phone, also in the presence of your lawyer via phone. Again, these first two phases were problematic because the publicity of the hearing was at risk. But now, with the introduction of more sophisticated mechanisms and sophisticated technologies, it is possible actually that there is a risk of no anonymity. If you consider that some of the court hearings may be streamed.
Erlis, we're approaching the end of our time, so
this is my second last. Yes. So again, all these problems that were there affected not only judges but also lawyers. So they said lawyers found the situation quite frustrating. They thought that their relationship between them and liars, them and their clients, was suffering. And of course, there were psychological effects to feel for people that were not well educated, because they were thinking that they were not being taken seriously by the judge and by the other parties in the hearing. However, we have to look at the bright side of life. And for one, lawyers consider that the remote justice saves time and money. And then we saw that this was one of the problems that the Dutch justice had. Again, parties finally, or because of this, saw that it was not always necessary to have all those hearings. Some of them are not necessary. I should say also that the review of the procedural rules that has been done in order to slim them down may also induce a new review of court procedures in order to allow for more technology and for less complexity in this future. There is still more need for funds and expertise in the Dutch judiciary in order to implement all these digital and new technologies. And again, I'm quoting also Professor Schmitz here, technology should be shaped around weaker parties in the court. And again, this is a good opportunity to show that courts are innovative and adaptable institutions. And I hope you enjoyed. This is it. Thank you, and I'm very happy to hear your questions.
So thank you very much, Dr. Themeli. If you can stop the screen share, then we'll see you in full size. So we do have one question from the audience. I invite you to list a few more, and I'm happy to offer a couple of my own questions and observations to kick us off. So
I hope I stopped sharing. Did I?
Not yet. You have to stop it from Zoom. Oh
yeah.
Okay.
Sorry, I have two screens as well, so.
It's not a problem. So first of all, I'm curious in your presentation of what lawyers thought about the transition to online hearings. You presented it as a sort of a perception of a trade-off between efficiency and the quality of the procedure or the access to justice in the proceeding itself. I wonder if that's the predominant view, that this is indeed a trade-off and that the only gain that is achieved in this transition is related to shortening the wait for the procedure or making it easier to schedule the procedure and so forth? Or is it more than that? Are there any substantive or qualitative benefits that were noted in these studies? So this would be a first question. A second one, which I wonder is sort of more of a policy response in the Dutch courts, given the collapse of the previous reform program and the experience that was accumulated during the pandemic. Would you think now that things would change? Would the strategy be different? Would they go for a smaller scale pilot project or anything of that kind? Or is it still generally the view of the court administration that that is not a desirable reform altogether? And then finally, just as an observation, I found it interesting that you noted it, and this also, I think, resonates some of Professor Schmitz's observation in her presentation, that this is an opportunity not just for, transforming the way communications happen in court, but also really an opportunity to re-examine how court procedure should look like. And as we engage in redesigning courts online, we have the opportunity to also redesign laws and procedures as a whole, and not just online procedures and interfaces. So you can pick and choose what you want to respond to, because we don't have a lot of time. And then we have a couple of questions from the audience as well.
Well, thank you, Ayelet. And it's very interesting because I'll start from your last comment about re-examining the look of the courts. And it is true that the Dutch government actually with the Quality and Innovation Project was indeed looking at that. They were, their intention was to look at the court as something that needs to be renovated in order to be an institution in line with our modern times, using modern technologies, what lawyers use in their everyday life and everyday working life. So indeed, this is the right time to make courts better and more modern institution. And usually, crises like this one are events that produce innovation, and hopefully this will produce some. And if we look at the Quality and Innovation Project, which was your second question, the intention after the freezing was to continue it at some point in the future. But then the decision to freeze it was 2018, then, well, some time is needed, then the pandemic happened. And actually, I think, and I hope that this pandemic would provide an impulse actually to improve the old project and to start a new one. However, problems exist. In concomitance with the Quality and Innovation problem, actually, the Dutch government started also a project to digitize small claims and in lower level courts, which is called canton courts in the Netherlands. The problem is that that was for cases lower than 25,000 euros and for people that would accept the digital procedure. But practice showed that that was very little used. And I don't know why, but my feeling is that digital procedures needs to be also a bit advertised in order to attract people, because usually lawyers are quite conservative and that goes to the first question about the trade-offs and what lawyers were really thinking.
I'll pass on my other question because I want to make sure we have time for some audience questions. So just quickly, Armin Holland, I hope I'm pronouncing your name correctly, is asking whether you think that given your focus on individual claimants as one-shotters and the potential of online courts to improve access to justice for them, should you also consider at the same time collective redress approaches as a means to alleviate these problems, and not just the propositions that you're making? And we could add that there are some ideas also presented in the scholarships about using technology to facilitate collective action, but that's perhaps, we can say a bit more about that in the chat, and our audience can also add.
Yeah, well, I think collective redress is a mean to solve certain type of disputes, but one-shotters, again, are those that you may consider as the weaker parties. And in my opinion, we should really take care of weaker parties, although they shouldn't be the only focus of courts. So yeah, every time you you design a reform, there is you need to make some trade-offs, and you need to consider certain parties and certain, yeah. I'm not sure whether or not I can answer that question, or
perhaps these are not the mutually exclusive solutions.
Indeed. They so the Netherlands actually has a law on collective redress that is quite discussed. So then, yeah, you see that they try to do both.
Thank you. And then a final question from Professor Klaus Heine, and I ask you both to try and be brief so that we meet our schedule.
Okay, I will be very brief. And Erlis, maybe you cannot even answer this question because it is very specific. Thank you very much for giving such a colorful picture of the Dutch way forward with ICT. And I wonder, are there any so-called ethnographic studies around about that? Because obviously the ICT is also shaping the whole ecosystem in which the judiciary makes its decisions, and had that any, so to say, effect on the decision, say, quality or art of decision making? I'm thinking a little bit about those studies as our colleague Jeff Rachlinski. Do you know anything about those studies?
Yeah, I don't know, and I think in Europe they are a bit rare so it would be actually very interesting to have them, and I think that it goes in line with my perception that weaker parties are also parties that are not represented in surveys quite often. But I think there is a study from Leiden that looked at access to justice for indeed based on ethnographic and niche groups, but it was before the pandemic, so I don't know.
Ayelet, you feel urged to say something?
No, I feel urged to keep us on time.
Okay,
so
then
we'll have to leave some open-ended questions and perhaps engage in further discussion in our next workshop. So thank you, Dr. Erlis Themeli, for your presentation. It is now my pleasure to introduce our final speaker for this panel. Last but certainly not least, Qudsiya Naqui is an officer with the Pew Charitable Trust Civil Legal System Modernization Project. And her work lies at the intersection of courts and technology, with the aim of developing a strong evidence base to support court technology implementation, one that promotes the efficiency, equity, and transparency of the civil justice system, particularly, as we've heard here today from all speakers, for self-represented litigants. And I should say in the preface that in the ODR and online court community, we're all very much awaiting the results of the Pew commissioned empirical studies that are now being conducted in the US to evaluate the use of technology in courts. It started even before the pandemic, but now it is even more interesting. And this effort, which is taking place under the court modernization project that Qudsiya is working on, is very relevant, of course, to our topic of discussion today, as their efforts are directed, among other things, to increase the availability and quality of free online legal tools that would help people navigate the complex legal system and complex legal problem even outside the system. And they're very committed to evaluating the impact of these technologies, as I mentioned earlier. So I think that's particularly important, as we've seen in our previous presentations today. So Qudsiya, thank you very much for joining us today. And Karen, if you can help drive the slides, that would be great.
Yes, thank you so much, Dr. Sela, and I'm delighted to have followed on the heels of Dr. Themeli and Professor Schmitz, and I hope that what I will present here today will build upon what they've discussed. And I promise to be very, I'll keep my remarks as brief as possible. I know we're tight on time, so that we have some time for discussion. As Dr. Sela mentioned, I am with the Pew Charitable Trusts, which is a nonprofit organization that is based, headquartered in Philadelphia, though I am working out of their Washington, D.C. office. And broadly speaking, the organization is dedicated to bringing research, data, and evidence to improve public institutions and inform policymakers. And I think Dr. Sela did a wonderful job of explaining the Civil Legal System Modernization Project, so I won't sort of repeat that again. So today I'm going to take a step back. So I really appreciated the perspective from the Netherlands and then Professor Schmitz' deep dive into online dispute resolution. I want to take a step back and talk a little bit about just the pandemic and how it sort of transformed courts overnight when it comes to technology implementation that had already been happening, but rather, rather slowly. So I just want to kind of tell that story and then offer some, sort of next steps that we can take. And I'll preface all of this by saying we are in the midst of doing some more detailed analysis of the role of that technology played in courts during the pandemic. So the data that I'm presenting today is it's kind of our preliminary findings. And so I want to just share that fact. So some of this data is still under development, but I thought it'd be interesting to kind of share some of this today. So we can go to the next slide, slide 2. So I wanted to first kind of set this up a little bit by explaining a bit for folks, since we have an international audience, about kind of how U.S. courts are structured and what that means for technology implementation and the way that the response to the pandemic was rolled out in the court system. So, state court systems so there's a federal court system that is separate and deals with, adjudicating and resolving disputes that are related to federal law up from, trial level courts to the Supreme Court of the United States. Each state in turn has its own court system that is with its own sort of governance structure. And so broadly speaking, we would divide these into centralized and decentralized court systems. So about 24 states, so this splits basically in half. So 24 states have decentralized court systems. So that means that decision-making, rule-making, budgetary authority is diffuse. So it happens at the county or local level. There's some sort of broad agenda setting that happens at the state Supreme Court level, but authority is diffuse. And then about another half of courts are what are called unified court systems. So there's some level of budgetary and other type of control, technology rollout control that happens at the state level at the top that trickles down, that local and county courts are required to follow. So what this means is there's 18,000 unique local, state, county courts in the country. And so that can result in a real wide range when it comes to how to fund technology, how to implement technology. So that's kind of the landscape, if you will, of how this works. And this definitely manifested and played out in the pandemic as courts were rolling technology out. Next slide, please. So I wanted to offer a little snapshot of what technology looked like prior to the pandemic to set the stage for what happened next. So I'm focusing here on sort of three different examples that are particular, but this was happening with relation to ODR, as Professor Schmitz mentioned, and various other types of technologies. But so courts were starting to digitize and use these online tools to facilitate both specific actions that you take in a court, so specific procedures like filing a case or notarizing documents, and other, and then also there very little, but there was some move towards moving actual court proceedings online. So as you can see here, over the course of 2 decades, so 20 years, it took 20 years for 37 states to adopt e-filing, and then 33 of those states did allow e-filing for self-represented litigants, for example. But again, that could vary across sometimes there was statewide e-filing for self-represented litigants. At times it was only in certain local courts, only for certain types of cases. So this was all kind of all over the map. It took over the same time period, 36 states had some sort of e-notarization, again, in some instances statewide, in some instances not. This looked really variant across courts. And then no court was really using video hearings or virtual hearings consistently at all prior to the pandemic. According to the National Center for State Courts, there were on the books for courts, 700 different types of rules across courts that they found related to using telephone or using virtual hearings. But again, this was not a widespread practice by any means. So that's kind of how things looked prior to the pandemic. So as soon as the pandemic started, this was accelerated dramatically. So in just 6 months, 12 states adopted some sort of e-filing. Virtual hearings became widespread. So 15 states actually waived their notarization requirements entirely, so people could submit documents without having to have them witnessed and signed by a notary. So this is pretty dramatic for court systems that were kind of slowly working towards technological innovations and digitization. So and this map here kind of shows you, what that explosion looked like. Next slide, please. And so here's an example of just to show you this explosion in 2 states, Texas and Michigan, that started putting hearings online. We were able to get some data from the court administrators about the rate of virtual hearings. So between April and July, Michigan had 35,000 unique hearings and Texas had 122,000. So that's from states that really weren't doing this on a broad scale. This was very significant, dramatic increases. Next slide, please. So before we get into talking about kind of the promises and pitfalls conversation, I wanted to play this video, which some of you may have seen, but sort of went viral in the US, which just kind of illustrates some of the things we're going to talk about in the next part of the presentation. So if you want to play the video, that would be great. I hope it works.
How do I play it?
You should just have to click the center of the video image. But if it doesn't work, then it went viral at least in Israel as well, and I've seen it in every corner of my social network. So I think we can safely assume that most of our audience has seen this.
Okay, so as you know, this is a video of a poor attorney in a court case who had a cat face that was generated by Zoom that he couldn't turn off, and the judge had to work with him until that was sorted out. So it was very funny. I'm sure all of you have seen it. So we can move to the next slide. Great. So I want to talk about some of the, I think this is just a funny example, but I mean, let's be honest that, you know, some of the concerns that Professor Schmitz and Dr. Themeli talked about have really significant consequences for people. And I wanted to kind of explain these and give them some color and category. So, and again, we touched on this earlier as well, but I would put the kind of pitfalls into two broad categories that I'll expand upon more. One is this issue of replicating challenges already existing in the court system and just bringing those barriers online. And then the second is the technology itself generating new barriers for people. So I wanted to share some examples of, you know, some of these, you know, the ways in which we can just replicate existing barriers, especially for self-represented litigants. So I'll just give a couple examples here, but you know, the fact that, you know, legal information. You know, you could have a form that's very complicated and would be very challenging for a self-represented person to use that has a lot of technical language and doesn't really have plain language. And if you just take that form and you put that form online, you're not really making the process easier for the person who's interfacing with that form, for example. So technology could be an opportunity to bring plain language, make things more accessible and clear, but it could also be a chance to replicate a complicated process that's hard to follow online. Another example is notice. Technology could really benefit people in terms of being able to have notice of their lawsuit, but if it's not sort of, again, in plain language or delivered in a way that's accessible, it could result in someone not being able to, you know, not being able to participate in the proceedings. So those are just a couple of examples. In the next slide, I'm talking about kind of how technology can create new barriers. And so I think these three examples are really important and I think can translate into court systems in other countries as well. So accessibility for people with disabilities is a really important one. So in analysis, Wesleyan University did an analysis of nearly 10,000 emergency orders from local and state and county state level courts across the country, and found that only a fraction of them had any language related to accessibility for people with disabilities and how to ensure any information for those folks about how to access proceedings if they have disabilities of various types. And then ditto for language access. Very few of those orders were, you know, had information in other languages. And these can be really substantial barriers for people. And so, you know, the example I like to give of this is if, you know, for someone with a mobility or a visual impairment, for example, having online procedures for courts could be really a boon, could really help that person who has mobility issues or can't travel to court access to the court system. However, if the online technology is not accessible with like a screen reading software or a braille display, that could then ultimately create a really significant barrier for someone. So again, this goes back to what Professor Schmitz was talking about in terms of usability testing, making sure these technologies are accessible, and also for people who speak various languages, and then also for people with disabilities. Another issue that's really come to the forefront, both in the context of online courts, but also other contexts like online education in the US, has been access to reliable broadband internet. So 25 million Americans don't have access to high-speed internet. And these types of disparities can also fall along racial lines in the US, which is something that's really important. So 25% of Black Americans, for example, report that they are smartphone-only internet users, and 23% of Latinx individuals in the United States report the same. So they only access the internet using a smartphone. So this can create a lot of challenges, both for just simply getting online and accessing the court procedures, and also for being equal in participating. If your opposing counsel is represented, your opposing party has a lawyer, they're sitting in an office on a desktop computer with a stable internet connection, we don't understand yet what biases that result in terms of decision making if that person is up against someone who is on a smartphone in a loud place, with an unreliable internet connection. So again, going back to the point about research and data and evidence, we need to study this more and understand how unconscious bias plays a role with parties who don't have meaningful internet access. So those are some of the barriers that technology itself can create. Next slide, please. So this leads me to my next point, which is what happens next. So courts at a broad level, court leaders have really been making an effort to respond to some of these challenges and potential pitfalls that I described. So for example, the Council of Chief Justices and the Council of State Court Administrators in the US, so these are leaders of state courts, have promulgated a set of guiding principles for online courts. They also developed a set of a resolution that emphasizes or creates standards for open data so that we can understand what's going on in these court proceedings by having access to having standards for collecting and reporting data that are nationwide and leveraged by all state courts. So those are just, and then at the state level, Texas has recently, not necessarily in response to the pandemic, but in the same time frame, developed a statewide framework for the implementation of online dispute resolution that now all counties, all of the 254 unique counties in the state, Texas is a decentralized court system, have to follow when they're implementing online dispute resolution. And then Michigan, in response to the pandemic, established statewide standards for virtual hearings. So these standards are being adopted and being promulgated, but we need to give teeth to them. We need to make sure that they're enforced and implemented in a meaningful way across the country, that in a manner that is consistent. And so also data. So, US courts, not all court systems report data or collect data in the same ways. So for example, based on a report that we published back in May about how debt collectors are transforming the business of state courts, we talk about the fact that Texas, for example, is the only state that reports on debt collection lawsuits across all court levels, including outcomes. And it's among only 12 states that collects any data about debt collection lawsuits, for example. So having better data to understand our court systems, including data related to identity markers like race, ethnicity, gender, disability status, et cetera, will help us to uncover inequities that might exist in terms of how court proceedings are being administered both online and in person. And then finally, research. Dr. Sela noted at the beginning, we have at the Pew Charitable Trust have commissioned a number of studies evaluating online dispute resolution in the selection of state courts. So bringing more third-party research to the table to help us better understand what impact these technologies will have in the long term. So those are some recommendations on how we can move forward. And I think Dr. Schmitz and Dr. Themeli have also emphasized this as well, which is wonderful. So next slide, please. So that I come to the end of my presentation, and I think I've reiterated a lot of what's already been said today, so I can wrap it up here. And I've provided here my contact information as well as a link to our website where you can find more resources. I also shared a couple of relevant recent publications in the chat, so please feel free to check those out, and feel free to reach out if you have any questions or would like to learn more about the research that we're doing. Thank you.
So thank you, Qudsiya, for a wonderful presentation. And you left us waiting to see more of what's coming out of your research, and really highlighted some of the key tensions that I think many courts around the world are now facing, and trying to make the right decisions about how to approach the transition online. And I'm curious and kind of want to hear your opinion. And again, I invite our audience to offer some more questions in the chat about this question of access to technology, when this access to the internet, broadband internet, or mobile phones becomes essential for accessing justice, not just in courts, but also in other governmental agencies. So we're talking here today about courts, but really we need to think about access to justice in broader terms, and just the ability to receive remedies altogether. And I'm wondering about this, and I'll highlight, I think Professor Orna Rabinovich-Ain is somewhere here in the participants. You can offer perhaps the link to the article, but in recent work that she's done with J.J. Prescott and Avital Mentovich, they've also noted some of the impacts of accessing courts online, and particularly accessing them also through mobile phones. And I think a lot of courts are struggling with this dilemma about making it more accessible so that more people can use courts. And that requires, possibly a mobile first strategy. I think that the Civil Resolution Tribunal in Canada has also taken this approach, given their data about how people use their platform. And then how accessing these important legal procedures through your mobile phone can impact the quality of your participation, especially when you're facing another party who's accessing them, as you've mentioned, in a better facility or a better device. And so what are kind of your thoughts about how to balance this tension? What would be the approach to get the right data to answer this question? Because I think, as we're talking about the promises and pitfalls, as in Erlis's terms, or in Amy's original formulation of sort of the key questions, I think that is one of the most important questions we need to ask. So I wonder if you have any data on this or have had a chance to think about this.
Yeah, thank you so much for that. And I have a few things to say about that. I think on a bigger, sort of thinking really big about this on the, I think in general, it used to be that the internet, access to the internet was sort of like a luxury item. And I think now it's more like a utility, like having light or heating. And I think from a policy standpoint, governments need to start thinking about it that way, and really trying to maximize access to the internet, because it is no longer a luxury. It is very much a utility that is necessary for daily life at this point. So that's just a general sort of my take. But in answer to your question, so I wanted to provide an example from the University of Arizona study that Professor Schmitz referenced. So when we were designing that study with the University of Arizona, it was a question of how we were going to conduct the user testing. And based on our understanding of, as you mentioned, the most people were using technology using a smartphone. And so we looked at that data in Utah in particular. And what we decided is the usability testing would be meaningless if we didn't do it on a cell phone. So it was a question of like, were we going to use laptops or are we going to use cell phones? And so we decided to center the study around observing how the platform worked for a mobile user. And so that's something to think about in terms of when you're doing research and you're doing user testing or you're trying to understand the impact. Always try to center it around how is how are most users accessing this technology? So I think that's a way of getting at it. And another, we're not at a place where we have universal access to the internet. And so a lot of states in response to the pandemic, for example, recognize that. So for instance, Arizona ensured that though they enabled e-filing, they also had an alternative option of drop boxes. So there were contactless drop boxes at the courthouses where you could go and file your paperwork and not have to go inside or interact with anyone or violate social distancing. So I think it's a combination of maximizing access, making sure we're centering the access around how the user is using the technology in terms of what device they're using. And then finally, recognizing that we need to have alternative analog or non-digital options so we don't leave people behind.
Right, and so as I think all presentations made clear today, we need more data, more studies, and a greater commitment to evaluate and then redesign and reiterate in design cycles. And I think some of our audience find it interesting to check out also the work of the Legal Design Lab at Stanford, Margaret Hagan, who's really leading the charge on how to ask these kind of questions and how to engage in user-centric design of court procedures generally and online court procedures, especially given these times. So yeah, definitely a difficult question to tackle. And I think it's interesting that, some of these efforts are probably more than 15 years long, with ICANN in California, trying to have these kiosks in courts to help people access them digitally. And so we may have to think, as you've mentioned, about online access as a commodity, that not as a commodity, but as something that is essential for basically like a human right in today's era. And then one final question I had, as you've mentioned, standards for virtual hearings, is how do you think about this in terms of enforceability and what's the role of ethics? And part of what I'm thinking of, and I think this is part of one of the criticisms that online proceedings and particularly online hearings often get, is that we don't know what's happening outside the screen. And there's a challenge of enforcing conduct and standards in this reality, especially when we compare this to the courtroom, where the judge presiding over the case and the public and lawyers and everyone else is able to offer this additional scrutiny and control for what is happening in the environment. And so I'm wondering, and this is sort of a very open-ended, open question about how can we make sure that ethics is preserved and that lawyers' ethical standards of conduct are maintained when we move online.
Yeah, I mean that's a really interesting question. I could probably spend an hour trying to answer, I think there needs to be appropriate guardrails. For the time being, I think some of these standards are really looking to have focused more on just kind of like how the proceeding is run. But I think you raise a really good point about what's kind of going on behind the scenes and, whether that puts a party at an unfair advantage. And I think that's definitely something that needs to be thought about. And as I was mentioning earlier, I think we really need to move from the standards we're just a huge leap forward and really important, but I think there needs to be a focus on operationalizing those standards. And I think that's happening in a lot of the state courts right now. And I think it's going to be an ongoing process. And again, like the broken records that we all are today, I think it's really hard to figure out how to operationalize those standards unless you have some sort of look back analysis of what happened in the proceedings, what the as related to what the outcomes were, and then what the litigants' perceptions were of whether they were being treated, you know, with procedural justice and were being treated equitably and fairly. So I think there's so much we don't know. And, you know, I would also point to, this is a slightly different context, but I think it's really useful. So Ingrid Eagley, who is a scholar at UCLA, did a study 5 or 6 years ago related to the use of video teleconference in immigration proceedings in the US. And though that's not a civil court in the same way as the state courts, that is a tribunal. And there were some really concerning findings out of that study about bias and discretion in decision making, and I think those are valid concerns. But this is really the wave of the future. I don't see courts turning back from using virtual hearings, and I think there's a lot of value to them. But yes, I think we need to think about how to concretely operationalize and ethically operationalize that process, and we don't know enough yet to do that. And I think research is really, really needed.
All right. Well, thank you. I think, yeah, we definitely have some open-ended questions that we've left here, but I thank our panelists, Professor Amy Schmitz had to dash this class and apologize, Dr. Erlis Themeli, and of course, Qudsiya Naqui, for giving us a broad and at times also quite detailed snapshot of what is happening in different countries with respect to the transition to online proceedings and how the pandemic has changed some of the dynamics, and really what are some of the big questions that are left unanswered and that we all agree we need more data on, and some more user-centered thinking in course, so that we can actually leverage this change and reach those goals that you've all outlined of improving access to justice and also the efficiency of the delivery of justice. So again, thank you all, and I invite you and our audience to take a brief 12-minute break. We're a little bit over time, and join us back here at 6 p.m. Israel time for the concluding keynote of our conference by Professor Richard Susskind, who is really one of the leading scholars, visionaries, and policy advisors in the area of online courts, legal technology, the future of the legal profession. And so I encourage you all to come back here, and we'll see you all soon.